Welcome, everyone. My name is Jamie Long, and I am a senior staff attorney here at the Public Health Law Center. And today we are going to talk about flavored tobacco policy enforcement options. To date, 134 California jurisdictions have restricted flavored tobacco product sales. And so we will try to walk through some of the best options for enforcing those for those who have a policy, and options for those who may be thinking about enacting one. But first, who we are. We're the Law and Policy Partnership to End the Commercial Tobacco Epidemic. And the partnership is a joint initiative between the American Lung Association and the Public Health Law Center. And we work to support tobacco control professionals to end the commercial tobacco epidemic in California. The partnership provides free technical assistance, research, training, and analysis to help communities pass strong local tobacco ordinances that are both effective and legally sound. And we do not lobby or provide direct legal representation. So the Public Health Law Center, where I'm based, is located at Mitchell-Hamlin Law School in St. Paul, Minnesota. We acknowledge that we are in the indigenous homelands of the Dakota people, also known as the Sioux Nation, and we appreciate the ongoing stewardship, spiritual connections, and lifeways developed in these homelands upon which the law school sits. All of our work at the Public Health Law Center is grounded in health equity. We are committed to removing all institutional barriers and applying an equity lens to our work to produce the best results for the communities we serve. So today we're going to be talking about a publication that we released last month from the partnership, talking about enforcement options for flavored tobacco sales prohibitions. But before we get into enforcement, it's important to talk about the ordinance themselves. We have a model ordinance that the partnership has released for tobacco retail licensing, and that includes a flavor sales prohibition in the model. So I'm going to talk briefly about a few of the provisions that are in that model that are helpful to think about to make sure that you are having good enforcement and setting yourself up for success. So the first is having a good definition of the flavored tobacco product. And the first component I'll talk about is making sure that you include language to the effect of what we have highlighted here, distinguishable by an ordinary consumer. So this is strongly preferred and recommended by us because it makes clear that the test of whether a product has a taste or smell other than that of tobacco is a reasonable person test and requires no special technical ability to be able to enforce. Also, the extensive list of flavors here is helpful for enforcement by demonstrating the breadth of possible flavored products, while also making clear this is a non-exclusive list. The second component I'll talk through is the prohibition language. And we have a pretty straightforward one. It shall be unlawful for any tobacco retailer to sell any flavored tobacco product. So what you'll note is that we don't have exemptions in here for menthol, for hookah, for other flavored products, and we also don't have any retailer exemptions. This certainly makes it easier to enforce, but it also, of course, makes it more protective of public health overall. And the third provision to talk about in our model language is presumption. So we include a presumption that if a tobacco manufacturer is making a public statement or claim that a product has a taste or smell other than tobacco, that there is a presumption that this is a flavored tobacco product. So this is important because it puts the burden on the manufacturer to prove a product is not flavored if they put out a statement or a claim to the contrary, such as a description of a flavor on a manufacturer's website or in advertising materials. So those are a few of the provisions we would recommend including in any flavor ordinance. And now we'll talk a little bit about flavor enforcement options. So there are a number of options that we'll be walking through, and at the end, we'll talk about which ones we recommend most and which ones we do not recommend. So the first option is that many products are going to be plain on their face, whether or not they are flavored. So these products pictured here have the description lemon or melon. Those are clearly flavored fruit products. And so it will be obvious to any enforcing official that those are flavored. Retailer guidance also from several cities that are included here gives some examples of how they are helping retailers understand what to look for. So San Francisco, for example, says that a product is going to be safer or more likely not flavored if they say that they're unflavored or if they say that they're unsweetened. In Chicago, they recommend looking for spicy or sweet as descriptors of flavored. but note that descriptors like mild or strong may not be indications that a product is flavored. In New York City, they use the examples of ice or a food or beverage as examples of flavored products. So those are some examples of what folks are giving retailers guidance for in determining whether a product is flavored. Public statements are another helpful way to determine whether or not a product may be flavored. So those could include statements from the manufacturer, and this goes back to the presumption that we mentioned briefly before. So it could be an online product description, it could be an advertisement of a product, or it could be communication with a customer service agent. And consumer reviews are another helpful source of information. So San Francisco, for example, recommends reading customer comments about a tobacco product and making flavor determinations. So this could include looking to YouTube reviews, TikTok, or Reddit. And Cheryl will get into this case a little bit more in her presentation, but a Massachusetts court in Cumberland Farms versus Yarmouth did uphold the relevance of both advertisements and online video reviewer statements against a challenge from tobacco retailers over a flavor determination. So if you are going to use some of these statements or reviews, it's important to preserve the evidence in case you have to defend against potential litigation. So an example would be to take a screenshot of a product description on a manufacturer's website and document the time and date, the web address, and the individual who recorded the picture. And this type of detail can also facilitate sharing evidence between jurisdictions. But it's not always going to be as clear as statements from a retailer or statements on the product face itself. So here are a few examples of products that are designed to be less clear by the industry. The first is the Jazz product from Black & Mild. Second is a product for vaping pods described as Fusion. And the third is described as Unicorn Puke. So these are not clearly flavored from their name or appearance, but they may be trying to be a concept flavor. So giving the consumer a cue or trying to signal a particular flavor to the consumer without necessarily saying that it is a fruit flavor, for example. So tobacco manufacturers, we know, are constantly innovating and developing new products. And often this is with the explicit intent of avoiding regulation, such as the flavor regulations we're talking about today. So this brings us to the smell test, which is our most recommended approach for how to make determinations on ambiguous products. And a smell test simply is determining whether an ordinary consumer can distinguish a smell other than tobacco. So using a layperson's sense of smell. And Cheryl will go into much more detail on this in her presentation. This is being used by some jurisdictions in California, and its most well-developed use is in Massachusetts, where it survived litigation challenge. And we recommend it because one, it does not rely on the industry. It is an impartial and reliable way to determine if a product is flavored, and you can do it with your own staff and not have to have expensive experts and not have to have take the industry's word for it. So one question that you might be facing in your jurisdiction is how to fund the purchase of tobacco products to be able to conduct a smell test. So one source that should not be used are Proposition 99 funding, which does not include enforcement in the lists of how the fund can be used. Proposition 56 may be a potential option. The guidance from the Attorney General's office specifically mentions enforcement of flavor ban laws or ordinances as an eligible enforcement effort for Proposition 56 funding. And another potential source of funding would be revenue from a local tobacco retail license fee or from collected enforcement fines. And some jurisdictions include language like we have in the Partnerships Model Ordinance, which would specify that the retail license should be calculated to recover the total cost of administration and enforcement, which would then clearly cover the purchase of products for an enforcement smell test. Another approach would be to have a prohibited products list. So this at the local level often is a non-exclusive flavored products list, which is easier to maintain for local jurisdictions than an unflavored products list. The image here on this slide is from New York's list. and New York's list is public and currently includes 59 flavored products. San Francisco also has a public list that currently includes 47 flavored products that are prohibited from sale. Chicago tried to keep a more comprehensive flavored product list, and they got up to 1,857 products before they stopped updating it in 2015 and found it unwieldy. So the benefits of maintaining a product list is that it can help provide some clarity to retailers as well as to enforcement staff. But the challenges are that it can be difficult to maintain given the constantly evolving market of tobacco products and the tendency for the industry to evade enforcement. And so keeping it up to date can require a significant investment of staff time and resources. There's also, if a list is being maintained, a need to clearly communicate to retailers that it is non-exclusive so that retailers aren't tempted to assume that any product not on the list is permissible for sale. One question that comes up is whether you can rely on another jurisdiction's list. And that depends on your ordinance language. It might not be the same as the other jurisdiction. So it could be helpful context to see that a product is listed as flavored, for example, on another jurisdiction's list. But unless your ordinance language is exactly the same, it should not likely be determinative. And so it may prompt you to do some additional follow-up locally, like a smell test, or perhaps requesting evidence sharing with another jurisdiction. There has been some interest in a statewide list, and this could certainly help with consistency of enforcement. At the statewide level, it would likely be easier to maintain an unflavored products list. And unflavored products lists are more difficult for manufacturers to manipulate because it's clear that if you're not on the list, you're not going to be able to sell your product. But a statewide list would not necessarily remove the need for a local jurisdiction to do some additional determinations, because jurisdictions, for example, may have chosen to go above the state approach to flavor enforcement. And so they may need to make a local determination as well. So folks on this call are sure aware of the upcoming Proposition 31 to vote on SB 793. And if that passes, there would be a floor set for flavor enforcement in the state of California with the SB 793 law. Local jurisdictions are able to enforce SB 793. So this will open up enforcement options for a number of jurisdictions that don't currently have local flavor ordinances. But SB 793 does not currently require a statewide list be developed. So while it may prompt the state to consider developing a list, there's no requirement in the law. So it could be beneficial for there to be some more legislative clarity about which entity would maintain the list and the responsibilities of the manufacturers going forward. Another question that has come up is whether a national list could be maintained. And the FDA certainly has been active in flavored products, starting with their deeming rule in 2016, where they've deemed all existing and future products containing tobacco or nicotine derived from tobacco subject to the agency's jurisdiction. That was later expanded to include all products containing nicotine from any source. And then in 2020, the FDA prohibited all sales of cartridge-based e-cigarettes not flavored with menthol or tobacco. And in April of this year, they proposed two important tobacco product standards, one to ban menthol in cigarettes, one to ban all flavors in cigars. And then in June of this year, they denied authorization to market all Juul products, which is currently stayed pending litigation. So lots of activity on flavors at the FDA, but to date, the FDA has not indicated that it's pursuing a national flavored list. So at the moment, states and local jurisdictions are on their own. Another possible approach is manufacturer certification. And this is putting the burden on the manufacturer to certify before a product that can be sold that it is not a flavored product. So this can help simplify enforcement because it at least provides a document that can be verified by an inspector, but it still likely needs to be independently verified, any claim that a manufacturer is making for accuracy. We know that the tobacco industry does not have a good track record for honesty in its products. And so there could definitely be an incentive for the tobacco industry to to mislead or outright not tell the truth. So certainly having a smell test or another backup could be a good option. Another approach that some have taken, for example, San Francisco, is to encourage the retailers themselves to contact manufacturers if they are in doubt about whether a product is flavored. And the final option that we'll talk about is chemical testing. So chemical testing is not an approach that the partnership recommends, and this is for three main reasons. First, there is significant cost and practicality challenges with testing the many new tobacco products that come on the market, particularly with the constant evolution of products from tobacco manufacturers. The second is that it's often hard to know what to test for because there are ingredients like cocoa and licorice that are often included in products to enhance palatability, for example, but they may not add up to a distinguishable taste or smell under the language of a particular ordinance. And then the third is that under the Tobacco Control Act, a local government cannot enact a tobacco product standard. Courts have upheld sales prohibitions as not preempted, but there is a risk that someone looking to challenge a flavor prohibition could argue that evaluating ingredients through chemical testing would be closer to transforming it from a sales restriction into a tobacco product standard. So you could certainly still argue as a jurisdiction that the chemical testing is designed only to determine what could be sold and not to control what manufacturers include in their products, but it would be likely a cleaner preemption argument with less risk to focus on the flavor imparted to the consumer and not the ingredients in the product. So in sum, we recommend most strongly the smell test approach, as well as looking at public statements and considering the use of manufacturer certification in conjunction with those two other approaches. And we do not recommend using a chemical testing approach. We certainly encourage jurisdictions with questions developing their flavor restriction ordinance language or working through enforcement challenges to contact the center. And here is our information to get a hold of us. And with that, I will stop sharing my screen and introduce Cheryl Sbarra, who is the Executive Director of the Massachusetts Association of Health Boards, to talk about some of the enforcement successes they've had in Massachusetts.
Okay, great. Thank you. And thank you for having me. As Jamie said, I am Cheryl Sbarra. I am the Senior Staff Attorney and the Executive Director for the Massachusetts Association of Health Boards. We provide technical assistance and legal education to local boards of health in Massachusetts specifically, and we have 351 local boards of health, all of whom have the legal authority to pass local public health laws. So I'm going to just give you some information about what we have been going through since 2014 was when we had our first flavored local regulation passed. And let me just see if I can move my slides. There we go. And this is what we're basically talking about when we're talking about determining whether something is a flavor or not. It's pretty easy if the product is labeled grape to know that it's a grape flavor. And as we do, as Jamie suggested, have a presumption in our regulations that says if it says dark chocolate on it, then it's flavored. But here are some of the ads that we've seen for Black and Mild Casino. So first, I'm going to talk about the case that Jamie mentioned, and then I'm going to talk about lessons that we learned through that case and through what we originally did when we were doing what we're calling the smell or the sniff test, and how we have been able to really come up with a guidance protocol that can be used. And again, it's just guidance. There's nothing etched in stone. We certainly don't want the industry to get a hold of this protocol and think it's something that's, ironclad and etched in stone. It's guidance that we have suggested to our field, to our inspectors, because it has been upheld. And well, you'll see what I'm talking about. So the town of Yarmouth is located on beautiful Cape Cod. It's a relatively small town. It has twice as many people in it during the summer than it does year round, and its medium income is about $60,000. So the Board of Health in Yarmouth enacted a local regulation, and they were the first ones to do this in Massachusetts. And at the time, the regulation just restricted the sale of flavored tobacco products, including e-cigarettes, to adult-only retail tobacco stores. No one under 21 could enter. However, that has been changed by our state law in 2019 that now prohibits all flavored products except in smoking bars for on-site consumption only. And we only have 24 of them in the entire state. The vast majority are in 2 urban areas, one in Western Mass in Springfield and one in Central Mass in Worcester. And then there's maybe 1 or 2 in a couple of other municipalities. And again, as Jamie mentioned, our definition of flavor is a characterizing flavor that doesn't taste or smell like tobacco. In this case, there was mint or wintergreen, because this was back in 2014, and we were basically mimicking the language from the City of Providence ordinance that was upheld by the First Circuit Court of Appeals. It had a menthol exemption. We didn't have a lot of resources at the Department of Public Health's tobacco control program, so we really needed to be very careful and cautious when we were looking at our language so that our municipalities would not get sued, because they looked to us for guidance and we couldn't put them in that position. That's no longer the case, but it was the case back in 2014. So Cumberland Farms is the entity that ended up suing the Board of Health in Yarmouth, and they are a regional business entity. They have hundreds, I think they have about 600 stores. Most of them are in New England, but there are some in Florida. Now, what's unique about them is they were privately owned. Now a UK conglomerate has them, but they still have the same business model in that there are no franchises. Everyone is an employee of Cumberland Farms, Inc. The managers are employees. So they buy their tobacco directly from the manufacturers. There's no third-party distribution going on in these stores. This is not the first time that they challenged. In this case, it was the product named Jazz, which you saw a picture of. They challenged it in many other cities and towns at the same time that they were challenging it in Cumberland Farms. It's just Cumberland Farms was the first retailer to actually sue on this. And their attorney, their in-house attorney is Matt Durand. And he came right out and told me that it was one of their best-selling products. They were going to fight tooth and nail to keep this product on the shelves. And actually, a New York City Philip Morris attorney called me about this product and told me several times that it just wasn't flavored. And I asked him if he had smelled it, and he said no, which is sort of, it's pretty, that's the popular sort of answer that you get from, at least I get from tobacco attorneys. So this is actually what happened. This is what the case was about that went to Barnstable Superior Court. We had a health inspector. He wasn't someone necessarily trained in tobacco control, but he was a health inspector. He did an inspection, and at the time, my agency, MAHB, the Mass Association of Health Boards, had a guidance document. We had hired a policy analyst who spent all of her time basically creating this list. And he just looked to the list and said, Jazz is on this list. We're ticketing you because it's a flavored product pursuant to this list. So those are the facts in that case. We again have lessons learned from the way this case was prosecuted, but that's what happened in this case. So the Board of Health held 2 hearings. They're a 5-member board. They're a pretty well-resourced board, so they have a good number of staff, and they're part of a tobacco control collaborative. So they also have a tobacco control program director who is responsible for all of the tobacco enforcement on Cape Cod, not just in Yarmouth, but on the entire peninsula of Cape Cod. So Cumberland Farms, Matt Duran claimed that it was not flavored. This was testimony that took place during the July hearing, and there was also a previous one in March that didn't get finished. It ended up going until July. So we testified, I did, and my colleague at the Mass Health Officers Association and the Tobacco Control Director, we all testified that it was a flavored product. We had smelled it. We knew it did not, it smelled like something other than tobacco. And the evidence that the board looked at through both of these hearings was the guidance list, copies of some of the advertising for Jazz. But what was interesting is the manufacturer claimed through Cumberland Farms, because they were supported by Philip Morris, because Black and Mild is one of Philip Morris's brands. And they basically said you can't really look at advertising because that's a third-party claim. It's not directly from the manufacturer, which is baloney, but that's what they claimed. We also submitted some peer review articles about the challenges and the harms of concept flavored products. I ended up submitting an affidavit relative to how we investigated Jazz. And then, of course, we had the statement or the declaration from Matt Durand and from a regional manager for Cumberland Farms that someone at Philip Morris told them that the product was not flavored. So, you know, they were basically saying it's not flavored because I said it's not flavored. So here are some of the pieces of evidence that we submitted. Here's one where Jazz is called a new flavor. It has its own unique sweet flavor that it's famous for. And here's some others. This one that they have a secret sauce. It's a unique sweet flavor and alluring bouquet. Here's one of the articles discussing the challenges with flavored products and how banning them or restricting them does produce a decline in youth smoking rates. And we did, again, as Jamie mentioned, we went online and saw all of these YouTubes. Most of them were done in front of high schools by kids that were clearly 14, 15 years old, and they would just give their own review of the product and what it smelled like. So the court, and you'll see the summary of the history of the litigation, but the court at one point remanded the case back to the Board of Health for a new hearing. And during that time, from July until November, and this is one of the challenges that we had with a list, was, we had a process where a tobacco manufacturer could appeal a decision that a product that was put on the list, and we would go back and do a smell test of that product. And if we felt that it smelled like something other than tobacco, we would leave it on. If we felt like it didn't, that it was tobacco, we would remove it. That's really challenging. And I think, in hindsight, we would not have taken any of the products off the list because they all smelled like something other than tobacco. So we, at the time, were thinking, well, we can't identify. Someone thinks it smells sweet. Someone thinks it smells like perfume, and people were coming up with different kinds of, what was the smell exactly. But what we needed to do was to just concentrate on whether it smelled like something other than tobacco. So in any event, that created some uncertainty. We were concerned that it created some uncertainty. And, the Cumberland Farms obviously questioned the reliability of the list since we had removed 2 products from the list during that time period. I offered a package of Jazz into evidence. I gave it to the clerk of the Board of Health and said, you're welcome to open this and smell it. And, Matt Duran jumped up and down and up and down and up and down, objecting. And the board said, you can jump up and down all you want, but we're going to smell it. So they opened it up and they smelled it. And they also considered the evidence that we had submitted previously with the ads and the YouTubes and all of that, and our own testimony that we smelled it and it smelled like something other than tobacco. So one of the members of the board was a very elderly gentleman who recused himself because he said he really couldn't smell anything. So the other 4 members of the Board of Health smelled the product and voted unanimously that it was a flavored product. Well, without that, voted 4-0 to 1 abstention, that it was a flavored product, and fined them on the product. Again, the evidence that Cumberland Farms submitted, and the first one I've got 2 asterisks next to because we're going to talk about that in the second half of this presentation, is they claimed that we really didn't know what we were talking about because they produced this scientific article describing natural variations in flavor and aroma among different types of tobacco. And that's really all Jazz was it was Virginia tobacco, and it was just a natural variation among natural tobacco types. And then again, they said that someone said it wasn't flavored. A manufacturer representative said it wasn't flavored. But interestingly, they never appealed the determination on MAHB's guidance list that Jazz was flavored. They never appealed it. So the judge in the Superior Court, which is our lower trial court, rendered his decision. And he looked at all of the evidence. And first, when a court is overviewing an administrative agency's decision, they're going to look to see whether there were errors that were so substantial that if allowed to stand would result in manifest injustice. They are not there to weigh evidence or find facts. They're only looking for whether there was an abuse of discretion or whether there was no grounds in which a reasonable person might deem it proper to support it. So there was a very high standard that the plaintiff had in this case, the Cumberland Farms had. And the language that came out of that decision was really interesting in that, the court said, just as Jamie said previously, you don't need to be a scientist or to determine whether something has a distinguishable aroma. You just smell it. And if it smells like something other than tobacco, it smells like something other than tobacco. And when you look at public health departments, we are constantly smelling things in order to determine whether or not there's a violation of the food code, sanitary code with mildew, whether dumpsters are sufficient in multi-unit rental housing to contain odors. I mean, we smell all the time. So Cumberland Farms appealed, of course, to the Mass Appeals Court, and the regulation was upheld on appeal. And again, the court held that you just had to determine whether there was an aroma other than tobacco, and you can use your own sense of smell to determine it. There's nothing in the regulation that requires any sort of specialized criteria or chemical test. It's really just a matter of common experience and common sense. You don't need any special technical knowledge to smell something. And we looked at sensory panels. I mean, we looked at all sorts of different ways to determine whether something was flavored, and we felt very strongly that if we just relied on the labeling of a product, that said I'm grape, that we might as well pack up our bags and go home, because we know that we are seeing more and more implicit flavors, not explicit flavors, and that's the industry's MO. So here's the procedural history of the case. You can get this later, but you'll see it started in 2017 and it concluded in 2020. Now, as I said earlier, we learned some lessons through the Yarmouth case, and we spent our time really thinking about what is the best way to actually conduct a smell test in order to determine whether a product was flavored or not. So what we did was and it was done by the technical assistance and legal education providers to the Department of Public Health's tobacco control program. And there are basically 4 of us that deal with legal and enforcement issues. And we held a training. It was, COVID was certainly not over, but people were going out with masks on. We held it in a neutral venue that I'll talk about in a minute. But what we really wanted to impart to these folks that were doing the enforcement, they were either health inspectors, tobacco control directors, other health department staff. We really wanted to give them some basic information. And what we wanted to go through the Cumberland Farms argument that, this is just a naturally grown product. There's no there's no flavor added to it. We went through the history and types of tobacco. We went through what a reference tobacco product is. We went through how to classify flavors. Then we actually did the sniff test, and then we went through the takeaways. So when you're looking at the history and the types of reference tobacco, and this is where the industry really tries to make you feel like you don't know what you're talking about. When your nose knows, it just does, but they're trying to tell you that you don't. So, we clearly know that smoking tobacco predates the Europeans' discovery of America by hundreds of years, and that there are basically 4 types of tobacco, and they're listed here. And the flavor of the finished product, and we had this natural tobacco with us, so that once we were done with this piece of the presentation, and it was so strong because you can only buy it in bulk, basically. So we had to keep it outside of the venue because it smelled so strongly. And the flavor of a leaf is going to depend on where it's grown, what the climate is like where it's grown, what kind of agricultural processes and post practices the farmer's performing on the product, and even the location of the leaf on the stalk. So the growing process, it ripens on the plant. I don't know if any of you have worked on a tobacco farm. Some of you may have, and you will have seen this. So it ripens, then the leaves are taken off the plant, and then they're gathered in bundles and they're hung on rods to dry, and then they're cured, and they can be cured in different ways. They can be cured by warm air in a ventilated barn, or smoked over a slow burning fire. So these are that's the growing process, and it varies for different types of tobacco and different types of farms. So what you end up with are these kind of labels on pure tobacco, and some of them are a little sweet, some of them are more bitter, some of them are mild and light. But when you smell them, you smell them, and this is what we had the field do. When you smell them, they all smell like tobacco. They don't smell like jazz. They smell like tobacco. There are subtle differences that maybe a tobacco connoisseur would know, or a seasoned tobacco smoker, but it would be like trying to identify, or me trying to identify, the difference between a red Pinot Noir and a red cab. I wouldn't be able to smell the difference between those two products. And that's basically what they were trying to make the argument in the case, that we just didn't know any better. We didn't know the difference between Virginia tobacco, Burley tobacco, and Maryland tobacco. But we did, because we smelled them and they all smelled like tobacco. So in addition to the way the product is grown, then you have chemicals being added to the casing or the sauce material. So for instance, if you've got a Burley tobacco that's low in sugar, they're going to add more sugar so that it produces a smoother smoke. And Jamie mentioned licorice. Licorice is added also to boost the sweetness in a product. But when the product is finished, it doesn't taste like licorice. It's just a chemical that's added, or an extract that's added, so that it improves the moisture holding of the characteristics of tobacco. It's an agent to smooth out the product. So then we conducted our test field study, our sniff test. And you might imagine, DPH is a state agency. It's a big bureaucracy. They didn't want to touch this with a 10-foot pole, but we didn't want to walk away from this sniff test because we had it upheld by a court. And we really think it's the only way we're going to be able to beat this industry at its own game, because they're not known for their honesty. That's a polite way of saying that they lie. So we did it on our own. We did not have any DPH staff with us. I told you we invited these folks who were involved in this. We held it in central Massachusetts at a venue that was off campus. It wasn't related to the government at all. And the only time you really need a sniff test is if the concept flavor is being challenged. So, it limits it to these kinds of products that you can't tell by their name what they actually are. So what we suggest, this came out of our standard operating protocol. What we believe is that you really should start with an open mind and no preconceptions. Clearly, if you have a cold, you're not gonna, or you can't smell, you don't partake in that test on that day. We ask people to not wear any perfume or cologne. We had nothing in the room. The only thing that was in the room was water. We had no food or coffee, just water, and no chewing gum or breath mints, nothing. It was open mind, clean room, and no food. So what we brought with us for this test, this sniff test, we asked the field to bring products that they had found that they believed were flavored, but that weren't labeled flavored. We brought a natural reference tobacco product. We brought Marlboro. We had, the natural reference was the tobacco leaves, the whole leaves. Then we brought a commercial reference, which was the Marlboro. We brought little testing cups, a score sheet, scissors to cut the products, and plastic bags. So 2 of us were in the back room opening up these flavored tobacco products, cutting them in thirds and putting them in individual cups, as you see on that picture. Our commercial product was Marlboro because it clearly smells like tobacco. We used products that weren't open for more than 3 days. And we would always suggest is to use a newly purchased product, not yet opened. And then we had some core categories. We had some core categories and some specific flavors. So the core categories, if you do research on flavorings, you'll see that the 4 categories are the ones that are listed on the left. And these are the core categories for flavored tobacco. And then the specific flavors for flavored tobacco are the ones listed on the right. So the instructions we gave them was to first smell the commercial reference tobacco individually, and there was no talking in this room. They were there to do an experiment and they took it very seriously. So each one had to smell the product, and we, the TA providers, provided them the product and make sure it went from one person to the next. And then we put it back closed in a container in the center of that table. The tables were all round. And then we asked them to smell product number one. And again, no talking. They had a sheet. They would record their findings on the sheet. When the flavor, that first flavor, went to everyone on the table, then one of us would remove it from the room completely. And because they were smelling a lot of different products, the best way to clean your olfactory receptors is to sniff your inner forearm. I never thought I would learn that, but now I know it. That's how whatever they're called, people that make perfume, that's how they cleanse their olfactory receptors. So this is the scorecard that we used. And they went through this exercise for 21 products. So what we asked them is the product flavored? And that means, does it smell like something other than tobacco? And if it smelled like something other than tobacco, could they identify the core flavor? And could they identify the specific flavor? So those were the 3 questions that we asked the field to answer. So the bottom line is they ended up smelling 27 different products. When we tabulated the results, 2/3 of them actually agreed that they smelled like something other than tobacco, answering the first question. 22 products were found to smell like something other than tobacco by at least 2/3 of the participants, okay, that those 2 bullets are the same. 1 product actually did smell like tobacco to up to 80% of the participants, and up to 80 to 90% agreed that many of the products smelled like something other than tobacco. So what we learned from looking at all of those sheets is stick to the definition of characterizing flavor. Does it smell like something other than tobacco? That's the only question you need to answer. You don't need to answer whether it's what the core flavor is or what the specific flavor is. If it smells like something other than tobacco, it's flavor. And I think that's it. And that is my contact information. For those of you who are younger than I am, this is a rotary phone. And that's it. And let me just stop sharing my screen.
Thank you so much, Cheryl. So folks can put questions in the Q&A if you have them. We have about 10 minutes or so for questions. And we had a few that came in ahead of time. And so we will start with those questions. So we had 2 questions that came in around Proposition 31 and SB 793. So the first one was, if voters uphold the law, SB 793, I realize that enforcement of that flavored tobacco policy would be weak to non-existent without a tobacco retail license. I wonder if there is any mechanism, however weak, that would serve to enforce flavored policies in jurisdictions that do not yet have a TRL. What would jurisdictions that have a TRL that doesn't explicitly include a flavor prohibition need to allow them to enforce the state law? And a second question says, we're funded by CTCP to achieve a flavors ban. And if Proposition 31 passes, what's the best pivot in terms of our mission? So SB 793 does allow local law enforcement agencies to be able to enforce it. The law doesn't specify which local entity should enforce the law, so each community will have to decide the agency best suited to enforce. And in terms of what to do if you don't have a local TRL, there are penalties built into SB 793. So tobacco retailers that violate SB 793 would be guilty of an infraction punishable by a $250 fine per violation. But we do certainly recommend TRL for enforcement purposes, and that incorporating a flavor prohibition into a TRL will allow for a lot more enforcement options than just the $250 fine. And we also recommend closing the loopholes that are in SB 793 for hookah, for premium cigars and for loose leaf pipe tobacco. So we would certainly be happy to work with any jurisdiction that would like to update their TRL or pass a new one. But for those that don't have it, you still have the option of enforcement for the $250 fine. A second question that came in was for rural counties, what are some good suggestions that don't, for a county that doesn't require a general business license and struggles with enforcement for doing flavored policy enforcement? Cheryl, maybe I'll let you start with that one.
Thank you. A lot of this, and I know in rural areas, it's tougher because the stores are so spread out, but a lot of this, as long as the industry isn't bringing in a lot of flavored tobacco products, laws tend to enforce themselves by reasonable people tend to comply with laws, especially if they are especially if retailers are competing against each other, and this is probably harder in a rural area than a suburban or an urban area. One retailer tells on the other. And if someone is determined to get a menthol cigarette, which is what we're dealing with now in Massachusetts, that's obviously the most popular flavored product in Massachusetts, they'll find where they can get it. And if they can find where they can get it, then the retailers that are losing customers are going to find who that retailer is that's selling it, and they're gonna drop a dime on them. At least that's what we found here in some of our rural areas. But we have tobacco sales permits here, so the ability to suspend or revoke a permit is really the best enforcement tool you have. But if you have the time to do the outreach and you let people know, and we had a lot of time to do that because of COVID, we weren't in stores enforcing, we were sending emails and letters and making phone calls to retailers to let them know that this was coming up. Not the best answer I can give, but it's what we've seen in our own rural Western Massachusetts.
Great. And I think some of
I
the
can answer Angela's question. Do you want me to answer Angela's question on Zyn?
Sure. So you read it aloud and then you can.
Sure. What about language that will include oral nicotine patches such as Zyn that do not contain tobacco leaf but are available in flavors? If they contain nicotine, they're covered by our regulation as a tobacco product. So as long as they're not FDA approved, which they're not, then they would be considered flavored products and we would enforce on it.
And I would just add that the model language that we showed earlier, the definitions that we include would also include products like that for California jurisdictions that are following similar language. So another question that came in is, have any jurisdictions created an allowed product list rather than a prohibited product list? So I know jurisdictions have considered this. Cheryl, I don't know if there are any examples in Massachusetts.
I know Kevin Struth, when he was in New York City, was a big proponent of that. But I think you addressed this, Jamie, in your talk, that there would still most likely be determinations that still would have to be made, depending upon, if you're going to keep it depends. If it's a state law and it's very comprehensive, then it would be great if you could just say, okay, if your product's not on this list, you can't sell. Much like we do in Massachusetts for registered firearms. If you're not registered, you can't, we don't care what your story is, you can't have a gun. So, but in this case, I'd really like to see someone do it and really be able to do it, but I don't know anyone who's been able to do it.
I don't have an example off the top of my head either. There's only 2 states right now that have passed laws, and that's Massachusetts and California. And obviously California is up for referendum next week, but it does require a significant amount of resources. And so local jurisdictions sometimes may not be able to have the resources to go through every product. So the next question is, We are looking for alternatives to traditional law enforcement as staff capacity in those departments is reduced as of late. Suggestions, Cheryl, for alternatives to traditional law enforcement?
The only, I can think of maybe two things. One, is there another agency that might be able to do the enforcement? You could designate them as enforcement agents. And the other thing would just to do a lot of inspection work and maybe not the ultimate fining work, but that's a tough one, because what I found in Massachusetts, having done this for almost 30 years now, is that your regulation is really only as good as your ability to enforce it. And I know that's been a challenge in California for a really long time. And I don't know whether your health departments have enforcing authority or whether it needs to go to police. Jamie, you probably know this because you studied California and I have not, but our boards of health have the enforcement authority. So I think that's a distinction between both the coasts.
Yes, and I think that, it does vary by jurisdiction. Some enforcement might happen through your public health department, some through code enforcement. So there may be some alternatives, but I think in terms of limited resources, the answer Cheryl gave on the rural one was a good start. And then I would just note that some of the enforcement options that we've talked through, like doing a smell test, which would require some staff time, but is not as intensive as, for example, doing chemical testing or some of the other approaches, or looking at product public statements are not as time intensive as some others, and certainly collaborating with other jurisdictions could be a good option. There are some jurisdictions, including many on these calls that on the call today, who are collaborating and sharing information. And so if folks are interested in being looped in with some of those discussions, you can reach out to CTCP or me, and I can make sure to loop you in. And then there was a question about whether the $250 fine per violation would be per product per day. And also, if we do have a local policy which has lower citation fees than the state law, which would stand legally. So I'll answer the second one first. If you have lower fees, you can take either approach. You can, both laws are still valid. There's no preemption under the SB 793 for local approaches. And in terms of whether it is for per product per day, I will share the language so that everybody can see it. Hopefully that will go out to everyone. Oh, I didn't put it to everyone. There we go. So this is the language. So it's $250 for each violation of this section. So leave it up to your code enforcement officials what for each violation means, but certainly that could be one possible interpretation as a per product.
And just as an aside, in Massachusetts, we have now a state fining structure that's $1,000 for the first offense, $2,000 for the second, and $5,000 for the third or more. And that has, we cannot pass a local law that's less strict. We can pass a law that's more strict, but not that's less strict than the state law. So our local programs now have to enforce fines that are that high. And in order to do it, they can't do it through the ticketing process because those only go up to 300. So we had to create a new enforcement mechanism for our local boards of health because they're the ones charged with enforcing this state law.
So I think this will be the last question we have time for, and it's around synthetic tobacco. So similar to the SIN question, but are there discussions around synthetic tobacco, and would they follow the same guidelines regarding a TRL flavor ban, or would they be considered in the SB 793 legislation? So I can take that briefly. So synthetic tobacco there are ways to ensure that those products are covered in your definitions of tobacco products. And so happy to work with jurisdictions on those, and they could be covered under flavor bans. When they are passed locally, there are ways to write the language to ensure that synthetic tobacco products are covered. Cheryl, I don't know if you wanted to add anything from Massachusetts perspective.
I was answering a question, not listening to you. I'm sorry.
No problem. Synthetic tobacco and covering for flavor
They would be
prohibition.
covered.
Yeah. Okay, well, that's the time we have. We're at the hour. So if there were questions that came up that we didn't get time to, then Cheryl and I will follow up with folks afterwards and offline. But I want to thank Cheryl Sbarra for being with us today and for the excellent information and presentation. And thank you all for your time and joining us for this webinar.